justices of the appeals court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the appeals court. We apologize for the delay, which, as you are doubtless aware, was caused by some kind of technical issue. I am Justice Rubin. To my right is Justice D'Angelo. To my left, Justice Smyth. We are rehearing a matter. It's number 23-1394, and it's the only case we will be hearing. Today. I'm sure we have lots and lots of questions for counsel because it's a complicated matter. It is number 23-1394 in the matter of JCS. It is impounded, so we're not using real names. And if the impoundment order is broader than that, let's follow whatever it is. And we will hear first from Attorney Cukier.
Thank you, Your Honors. May it please the court. I was asked by Judge Phelan in the lower court after a Zaltman trial to brief 5 questions of law that he asked me to bring to this court. They relate to the right of a incapacitated person or protected person who is under conservatorship and guardianship at the time to select and retain counsel. And the questions include whether or not there is a ability of that incapacitated or protected person to fire and discharge counsel. The curious thing procedurally about my position before the court today is that at the trial of this matter, I was appointed by the court to serve as counsel for the protected person. And in that capacity, my job was to promote his rights to independence, autonomy, privacy, and that I did. At the end of the trial, the court appointed me to serve as conservator.
Did you have a position on capacity in your prior role as counsel for the, petitioner?
JCS wanted me to have the guardianship and conservatorship discharged.
Of course.
So my role was to attempt to discharge both appointments.
But did you have a position on what the standard would be for the propriety of hiring you or hiring who he wanted? Like, what was your position on that?
Yes. At the time that I was appointed, there was already a guardianship and conservatorship in place. Had there not been, then my position would have been that the presumption of capacity in our law would have permitted JCS to retain and select counsel, because there would have been no appointment of any guardian or conservator. There might have been a medical certificate filed, there might have been a petition filed, but there's a presumption of capacity, mental capacity, even once the petition is filed. It's not until the court has adjudicated a lack of capacity that the presumption changes.
And what was the outcome below?
The outcome below was that JCS lacked capacity to select and retain counsel.
And what, again, I'm just going to ask you, but maybe you don't have an answer to this. What did you say the test was for capacity in your role as someone arguing for the autonomy and independence of the incapacitated person?
My role at the time in that trial was to attempt to show that JCS had capacity, and that was the position that I took.
And what standard did you argue for, if any?
I argued the presumption of capacity.
So much like amici do here?
Correct.
Okay.
Counsel, can I ask you some procedural questions? Because, just because. I know you have a lot of experience. So I'm going to ask you about a pre-Zaltman hearing. The beginning of this case, JCS gets brought into the court because there's a question whether he is competent at all because of the police finding him, et cetera, et cetera. In your experience, a petition gets filed, presumably by a doctor or whatever. Who represents the petitioner at that point and how?
The petitioner is a person who's interested in the welfare of a person who is believed, factually, to lack capacity. That person can retain counsel, whether it's a private lawyer, counsel for a hospital, counsel for an agency such as DMH or DDS.
Okay, so DMH, et cetera, well, we'll just use DMH as the party. They have their own lawyer, comes in and says, JCS needs assistance, not competent. Who represents JCS?
JCS is not represented at that point.
At all?
At all.
Okay.
But has a right under Chapter 190B, Section 5-106, to request the appointment of counsel, and anyone else who's interested in the matter can request the appointment of counsel, and the court can act sua sponte as well.
Okay, and I am going to use language that's probably not correct. The person has no idea what's going on, maybe even nonverbal. Does the court in that circumstance appoint a lawyer to represent his interests?
In the probate and family court, if the judge believes that there's a reason for the appointment of counsel, such as Judge Phelan believed there was in the JCS case, the court can do so. But to your point, an individual could potentially come into court, be the respondent, the subject of a petition seeking to put him under guardianship or conservatorship, not have counsel, and not have the wherewithal to know that Section 5-106 permits a request. If the request is made, the appointment shall occur. It's a mandate that the judge shall appoint counsel.
So in my prior role as a district court judge, it's a little different. So a person is at a hospital, an emergency commitment, that person gets appointed a lawyer, and that lawyer contests, and it's a CPCS lawyer, that person contests that they're usually 99.9% of the time that they're mentally ill and should be confined. That is not your experience in the probate and family court, that sort of automatically that person gets a lawyer, it's up to the judge?
Yes, Your Honor, there's a distinction in the district court, whether it is a criminal proceeding or whether it is an involuntary psychiatric hospitalization proceeding. There's going to be a deprivation of personal liberties and freedoms to move. There's going to be a physical confinement. On the probate and family court side, with a guardianship or conservatorship, it's decision-making rights, but there's no deprivation of an individual's ability to move about or to ask for the appointment of counsel.
No, but there's an almost complete deprivation of their liberty, right? I mean, it's true they can, maybe if they can walk wherever they want or whatever, but they can't do anything. They can't get a dollar out of the bank. They can't, depends what the guardianship or conservatorship. Do you think that we have authority to order that a lawyer be appointed in all of these cases?
Do you require counsel in every case?
Yes.
And this, again, I'm trying to distinguish. This is pre-Zaltman. This is a petition's been filed saying a guardianship or conservator or both needs to be appointed for this person because fill in the blank. Now to Judge Rubin's question. Do we have the authority to order that in those circumstances, somebody needs to appoint that person a lawyer because although their liberty is not at risk, there's certainly a deprivation of rights? Do you think we have the authority to order that a lawyer be appointed in that circumstance?
The court has authority, although it would mean expanding the scope of a statute that does not say that. The court doesn't say that counsel shall be appointed in every case. It says the court shall appoint if the suggestion is made.
Is there a statute that says in every involuntary hospitalization for, presumably for psychiatric medication, that a lawyer must be appointed when the petition comes in?
Yes, that's a different chapter of the laws.
But there is a statute, so that's why that's done.
Yes. Yes, that's under Chapter 123.
So in this circumstance, again, so we can focus, what is the authority that Judge Phelan on his own, in his discretion, appointed a lawyer for JCS.
Yes, Judge Phelan appointed me under, sua sponte, under Section 5-106 of Chapter 190B.
Okay. All right. So in this circumstance, and maybe in certain others, JCS is represented pre-Zaltman for purposes of guardianship conservatorship.
There had, in this particular, the facts of this
Had
case.
already been one.
Correct.
Okay. So prior to a decision on a guardianship and a conservator, presumably, maybe I'm wrong, the trial court under 190B 5-106 can still appoint a lawyer even before that circumstance, correct?
Yes, as I read the statute, it can be done at any time after the petition is filed and throughout the proceedings. And I would argue to this court that throughout the proceedings should be expanded to encompass petitions to expand, and the period when accounts are filed, and the period when guardianship care plans are filed. In other words, once a petition is filed, even if it goes to decree, I believe that the courts should still have the opportunity to appoint counsel at any time for anybody under guardianship or conservatorship.
Okay, but I want, again, I'm trying hard to do pre, post, et cetera. Pre-guardianship, pre-conservatorship. In this case, we'll use the name. JCS comes in and has lawyer A and says, I hired lawyer A to represent me. Does the judge at that point first have to have a Zaltman hearing? Because why not?
Because at that point, the presumption of capacity should apply. There's no adjudication of incapacity. And once there is an adjudication of incapacity, the court can go a step further and void the contract, so that the contract with the lawyer can be avoided. The court can intervene if the court believes that there's a problem with the incapacitated or the allegedly incapacitated person's selection. But before there's
The court has the power to void a freely entered contract by a person who has not been adjudicated incapacitated?
No,
How
only
would
after
they-
the incapacity.
Only after, okay, I
adjudication.
see.
Exactly. I understand what the court's asking. There's two scenarios here. One scenario is before there's any appointment of a fiduciary. At that point, the presumption of capacity should hold, and the individual should have the right to select counsel.
But here's my issue with that. And I'm, again, it's not with you. This is amazing for us to have this. The petition is filed by, again, in our hypothetical, DMH. DMH in its petition makes it crystal clear the person doesn't know what's going on. But yet that person has hired a lawyer and is presumably spending money that might otherwise maybe shouldn't be spent. We have to have a whole hearing with this lawyer who maybe shouldn't have been hired in the first place, and then the judge says, that person doesn't have capacity, I'm voiding the contract between JCS and lawyer A. That can happen. There's been a whole hearing where JCS is represented by lawyer A, but the judge after that hearing says, JCS shouldn't have hired a lawyer, he was incapacitated.
This happens in other scenarios as well. So an individual comes in to court because they are the respondent in a guardianship or conservatorship petition, and perhaps they have just sold a piece of real estate and signed a purchase and sale and a deed. And perhaps after the guardianship or conservatorship, the conservator says, or the court says, this person should not have signed the deed. They didn't know what they were signing at the time. They gave something away for far less than fair market value. And then the court can at that point take it a step further and revoke the deed or revoke a will.
The lawyer presumably has an action in quantum merit or something for the work they did before their contract was voided?
Yes, or potentially could seek to file an attorney's lien because the matter was in court.
And this idea of appointment all the time or whatever, the appointments under 106, if the person has resources, are paid for by the person. So the judge isn't just saying, we'll get you a CPCS lawyer. The judge is saying, well, you've got a little dough. I'm appointing Jane Doe to be your lawyer. She charges $285 an hour.
The court can appoint from the CPCS list. I should mention also that in petitions seeking authority to treat with antipsychotic medications, because that is considered a restraint of a type, the court does routinely, as a matter of course, appoint counsel for the incapacitated person.
All right, so now we've...
And who pays for it if the person has money?
The court will decide on a form whether it's paid for by the estate of the alleged incapacitated person or by CPCS. Part of my thinking in this matter is that the system is highly burdened, just factually, with not enough lawyers out there and not enough funding to pay for lawyers. And if there were counsel appointed in each and every matter, they would necessarily be adversarial, where many of these matters don't need to be. There are many people who go through the guardianship process or conservatorship process who, rather that it not be adversarial inherently or contested inherently, family members who don't want to drag their business through court and who don't want to injure family relations. And so I would say that having a rule that requires the appointment of counsel in each and every case would throw such a burden on the court and families as to be difficult to manage and potentially deleterious to families.
We're going to keep going even though your red light is on, because I think we're not remotely close. Now let's take the not hypothetical question of someone who wants to remove a guardian or a conservator. I hope, not everyone, most people would agree we can't have the conservator or guardian hiring the lawyer for them. They have an adverse interest, however much they may feel that they are acting in the best interest. There's an inherent conflict there. And I think we certainly all agree that you have a right to a lawyer. I think most of us would agree, and you need one, right? So the person comes in, and they have hired a lawyer. I don't really know what that means. I mean, many of these people are incommunicado. Who is this lawyer? How did they show up? How come there's three of them? How, right? Like whatever it is.
Isn't that where Zaltman comes in?
Zaltman was pre-UPC, and
I'm gonna ask you your position on that
Okay.
versus the amici. But isn't that the situation where a Zaltman hearing takes place? The person who's already been appointed a conservator and/or guardian wants to hire a lawyer. Presumably, conservator or guardian contests that and says, no, this person shouldn't be able to do this. That's where a Zaltman hearing takes place, correct? The court has to decide whether they're competent to make a lawyer, or have a lawyer, sorry.
Yes.
Okay. So do you take the position that I think amici does, that the MUPC has sort of, in some sense, overruled Zaltman?
100%.
Tell me why you think it's overruled as opposed to maybe modified it a little bit.
The UPC has as its basic tenet that the probate and family court should limit guardianships and conservatorships. They should not be plenary in the first place. And at the outset, there should be some consideration by the judge as to what the judge is seeing and hearing. And some judges do ask that counsel select limitations as a matter of course. And that's what the MUPC set out to do. The MUPC requires the appointment of counsel upon the suggestion of any person, not just the respondent. And of course, the court has equity power and can certainly appoint counsel at any time. The court can also look into details of capacity, going way back to the 1970s in the guardianship of Bassett, which was a case that that found that people can have capacity in some areas and not others. The court at that point understood that guardianships and conservatorships can be limited based upon the actual factual levels of capacity of an individual. And so if somebody comes into court and wants to have their own attorney, the court can make that selection without going through the highly encumbered, enormously expensive Zaltman procedure. I think the Zaltman procedure is...
Let's say I read the statute just as you do. I take it what you're saying is, given that there can be narrower guardian and conservatorships, the person is presumed to have the capacity to hire a lawyer. And so here they are, and here's their lawyer. But presumably, in almost every case, the guardian and conservator who don't want to be removed will challenge that hiring. So doesn't the MUPC, is that what it's, doesn't it merely shift the burden? There's a presumption, but it must be able to be overcome, right?
Yes.
All right. How do you figure out whether it's overcome without holding, with a different burden of proof, a Zaltman-type hearing?
Once the guardian and conservator is appointed, now we have an adjudication of incapacity. But the court makes the point here that it would be a conflict of interest for the guardian or conservator to be involved in the selection of counsel or in the representation of the person who's been adjudicated to lack capacity. That is why I believe that the court should clarify that Chapter 190B, Section 5-106 applies at that point after the case goes to decree.
You're saying there is no person withstanding to challenge the hiring of that attorney, right? Because the only other parties in court, I mean, I see this stuff about any person. I assume that's actually limited in some way by interest in well-being or something. It can't just be a person off the street, I would think, but I have no idea what the statutes say. So the person comes in, they have hired a lawyer. In reality, they have the capacity of a 5-year-old child.
Yes.
They can speak, they can say, will you be my lawyer? They can do all of that. But no one is arguing that I can see that children are allowed to do that. Maybe that's wrong, but there's no presumption that a child. But let's say there's a presumption. So there's no one who can raise with the court this issue. The guardian and conservator can't because they shouldn't have anything to do with it. That actually sounds reasonable. But so no one else can. So now we've got a person maybe with the capacity of a 5-year-old child and a person they've asked to be their lawyer. Now that's who represents them. Isn't that dangerous?
So the guardian or conservator can move to strike, as was done in the JCS case.
Oh, I thought you said they couldn't anymore because they have this conflict.
They can't represent the incapacity.
Oh, no, I understand that. I understand that. All right, so they moved to strike, and now don't you have to hold a Zaltman-type hearing? But the burden is on the...
That was done. That's precisely what happened.
Okay, but I'm trying to figure out, you said that the MUPC overruled Zaltman, and we don't need to have this expensive hearing.
Yes.
Which sounds great,
Yes.
but in fact we still do, because in almost every case, I'm guessing, the guardian or conservator is going to challenge whoever they hired and say, my ward can't possibly understand what a lawyer does.
So there's a difference here. Under the Zaltman case, special counsel is appointed for the person who is now under guardianship or conservatorship. And in the JCS case, even though I was already counsel, another attorney was appointed, my sister attorney Tracy Galloway, to be Zaltman counsel. So we had 2 attorneys for JCS when perhaps only one was needed. We have the Rules of Civil Procedure, Rule 35, that permits an examination of mental capacity, and that was done in the JCS case. The issue could have been resolved right then and there. The court could have looked at the medical data after the Section 35 exam and made a decision whether JCS had capacity.
Okay, but there still has to be a hearing if there's a motion to strike, right? There has to be a hearing on it. The guardian and conservator, or whoever they are, will be represented by whoever they're represented by, and the incapacitated person will have the lawyer they chose. And at the end of the hearing, the judge will conclude either, yes, it's fine, or no, it's not, depending on whether the guardian has proven what? Capacity to hire a lawyer.
Whether or not the judge has determined it, yes. The guardian isn't saying...
So it's still, we still need to know what the standard is.
Yes.
It's just the burden's the other way.
Yes, we're back to the standard. It's more than a contractual capacity. You know, the case proceeded as a contract case, so I was...
No, I think it's less, actually, than contractual capacity, right? Because the rules of professional conduct
Yes.
describe having a client
Yes.
with certain limitations. And presumably, now maybe it just is referring to appointed counsel or so, you know, but it doesn't say that. Presumably, the implication is that person may well have a lawyer who they're paying.
Yes, so under the the rules of professional conduct, which add dimension to the entire issue, that's really where, it's the rules of professional conduct, I think, that answer the question here because of the dimension it adds in Rule 1.14 and 1.16. In 1.14, a lawyer shall have as normal a relationship as possible, but if the lawyer has reason to believe that an individual has diminished capacity and is in need of protection, the lawyer can take just those steps, those few steps that are necessary for the protection of the individual.
Here's where I question that. We're at exactly the position where we just started this discussion with Judge Rubin. The person who maybe have the intellectual capacity of a 5-year-old has hired a lawyer. You go through the Zaltman hearing. The judge, after the Zaltman hearing, determines the person does not have the capacity to hire a lawyer. He voids the contract between the lawyer and the person with the 5-year-old limitations, correct? That's where we are so far.
Okay.
Okay, but you believe that under the UPC, that person should at least have the right to hire lawyer A. Is that correct?
They should have the opportunity to do so, but the court, as in JCS, so JCS had hired 3 or 4 different
Correct.
lawyers.
And using the money that a conservator had been appointed to protect the well-being of JCS. Are you taking the position, and I think this is what the amici is saying, that that's okay?
Only before the appointment. Once the appointment of a fiduciary is made, then the conservator should be able to select counsel or the court, and the court always can.
Wait.
So here, so we're now, person is under the conservatorship / guardianship,
Right.
wants to hire a lawyer. You believe that once that decision has been made, the person shouldn't have that choice.
That's right.
Okay, what do we do then? If again, I'm sorry I keep saying it this way, it's the only way I can. The intellectual person with a 5-year-old wants to hire a lawyer. The court just ignores that?
No, the court doesn't have to ignore it. So under our laws, the court will give great weight, will accord great weight to the expressed preference of the incapacitated person. And the court can decide whether or not the individual seems to have sufficient understanding of the legal interest at stake and sufficient understanding of what it means to participate with counsel.
How does that come to the court's attention? Because I know that's what Judge Rubin was going to ask.
With a Section 35 exam or any type of medical documentation.
Person is living his life, but is under the conservatorship, the guardianship. What does that person with the 5-year-old intellectual capacity do? Does that person file a petition? How does it come to the court's attention that they now, or maybe let's take it a little further. Maybe the person gets medicated.
Yes.
and now is doing better, maybe does have a better intellectual capacity. How does it come to the court's attention for that person to say, I no longer need the guardian/conservator?
Many individuals will say that to the judge.
When?
How do they even get into court if they can't hire a lawyer?
JCS got to court and said, I
He hired a
object.
lawyer.
Lawyer helping him. What about the person who, is
JCS
there a
had-
review process every year?
The time I was appointed, JCS had no lawyer. JCS went on his own, pro se rather, to court. This was back in, this was October of 2018. At that point, a guardianship and a conservatorship had been allowed, and there was a petition, a further petition pending, seeking authority to sell his real estate. And JCS came to court and said, don't do this. And Judge Phelan said, I hear you, I'm appointing counsel, and appointed me.
All right, so
And he got a lawyer, attorney.
Yes, then he went on to retain 4 different lawyers.
I have to say I'm a little baffled by your answer to Judge D'Angelo about what happens once a conservator has been appointed. I thought the whole point of this case was, does the incapacitated individual retain the presumption that they can hire a lawyer? So in all cases, these are cases about removing the conservator. In all cases, I thought you said they had the presumption. But then he said, but once a conservator is appointed, can they hire a lawyer? And you said no.
That's right. There's 2 presumptions. There's 2 different points in time. One is pre-adjudication. At that point, there's a presumption of capacity in all
I'm sorry,
areas.
there is no pre-adjudication if the person already has a guardian and a conservator in place, like JCS.
Yes.
They show up in court, and there's the guardian, and there's the conservator.
Yes.
And so you're saying he has no presumption, right? He's
No-
already been adjudicated incapacitated.
Right. And so the decision to retain counsel should fall to the court or the conservator or guardian.
But you said the conservator and guardian are conflicted. We can't have them deciding whether he should have a lawyer to remove them. Right? You agree with that,
In
I
a
think.
removal situation, the court should intervene to appoint counsel or to listen to
So
the-
he can't hire a lawyer at all. He gets appointed counsel every time, notwithstanding that the statute says nothing in this shall abridge his right to. You think he has no right to choose counsel once he's in a conservatorship?
I do not believe he's got the right to select counsel, but I believe that he has the right to express his preference, and that the court, under the Sakowitz case, Belchertown v. Sakowitz, and all the case law after that, says very clearly that the court shall accord great weight to the preference of the incapacitated person.
Which is consistent with the UPC.
Yes, in Chapter 190B, Section 5-106, it does say that right in the statute. It says nothing will abridge the right of the
That's why I
incapacitated
was trying
person.
to get different timeframes. We have pre-guardianship conservatorship.
Yes,
We have the first time after that the person wants to hire a lawyer. And then we have post, which we haven't gotten to post, which now there's been all these things.
yes.
We have a conservatorship, we have a guardianship, we have the first Zaltman hearing, I guess we'll call it. The judge said, no, he's incompetent. I void the contract with lawyer A, and I'm sticking with the conservatorship and guardianship. Later on, it's the same standard, you would say, after that, correct? Not a right to a lawyer, but can bring a petition to say, I want to remove somebody, and the court at that point, if based on, I guess, the paperwork, could appoint a lawyer under 5-106.
Yes. And the court can consider the
This
selection of
seems,
the
and
incapacitated
I think
person.
we're going to hear from amici, I'm hoping. This seems contrary to what they said. They seem to say the person has a presumptive right to hire an attorney, and this being a case about removal, I assume what they mean is even though he or she has been adjudicated in need of a conservator and a guardian. I think that's what they're saying. But your position is different, I think. Your position is once they're appointed, the incapacitated person cannot hire a lawyer, notwithstanding the rules of professional conduct that indicate an incapacitated person can have a lawyer. but that the court is the one who hires the lawyer, listening carefully to the person saying, but I've met Jane Doe and she's the greatest lawyer ever. Look at this thing she gave me. And the judge can decide, well, that makes sense and I'm going to do that, or no, this is a person who's taking advantage of the incapacitated person. They need a lawyer, but I'm going to pick someone else.
Yes, the JCS case was not a removal case. So it didn't take place in the context of seeking to remove the guardian and conservator. It was a case that took place because JCS did not want his real estate sold. That was the context.
Okay, but he had, same difference. He had a guardian and a conservator. He comes in and says, I hate what they're doing.
Yes.
Don't let them do this.
Yes.
And he obviously needs a lawyer for that just as much as he does for complete removal.
Yes.
Can I ask one final question that we started with? Currently, do you take the position that you said most, some, not all, judges are not limiting the role of the conservator and/or the guardian in a way that you think is consistent with the UPC?
Not all judges sua sponte ask the question, and not all petitioners bring forth a set of limitations.
Okay, great. Thank you very much.
Thank you.
Wait, you got a question?
I do,
Judge?
actually. As I hear you, Counselor, my understanding of the judge's authority to appoint an attorney is more limited than your interpretation. You've cited 106 as a judge being able to appoint an attorney, but doesn't the language of 106 speak to retaining?
It does. It can be either. So 106 allows an individual to request counsel, or allows anybody to request counsel for an individual who is the respondent in one of these proceedings. And it speaks to the court's permission of that. An individual can say, I would like my own selected attorney, and the court shall consider that person. The court shall make an appointment. It doesn't have to be the person selected by the allegedly incapacitated individual.
But if the individual, the incapacitated individual, does not have funds, what happens?
Then CPCS will pay.
Under what provision?
The court will make an appointment, just as it does in the Rogers case law, which is the petition to expand authority seeking authority to treat with antipsychotic medications. In all of these cases, CPCS counsel is appointed, and there's a order form with a box check that says that CPCS will pay rather than the estate of the allegedly incapacitated person.
So we'll hear perhaps from your sister in a bit that best practice best practice would be to appoint an attorney in every proceeding, and you're, I won't say adamantly opposed, but you're opposed to that.
That's right, Your Honor.
And
I don't think we're going to hear that. I think we're going to hear that the person should be able to hire in every case, but we'll find out.
Well, we'll see. We may revisit the symposium at Syracuse. But your position is that that would add to more litigation. It wouldn't be healthy for the system or potentially the respondent or the incapacitated.
It's a necessarily adversarial position. These are cases where we're trying to protect individuals. These are very sensitive cases. These are families very often who come in with their loved one trying to make decisions for a loved one who's going to potentially make a bad decision based on a lack of ability to exercise rational thought process. Sometimes these are individuals who have been cared for by their families for the past 40 years at home, and now we need to have somebody in place because the parents are aging. At that point, do we start the wheels in motion for what's going to be an inherently adversarial process? It's also an expensive process. It's a protracted process. It requires many trips to a physician for medical certificates. It requires airing your public business in court, and potentially every year. It's a burden for families. I would argue against it.
Can I ask about Section 106, 5-106? I'm going to read the final sentence of subsection A. This section shall not be interpreted to abridge or limit the right of any ward, incapacitated person, or person to be protected to retain counsel of his own choice. You've just said once they're incapacitated, they can't hire. That sentence says they still have, it doesn't say what the scope of the right is, it doesn't say, but it doesn't say, the implication is they still have a right to hire a lawyer, and you've said they have no such right. Well, how do we square that?
So my understanding of that sentence relates to an individual's right to express their preference and to make a selection.
It doesn't say that. It says to retain counsel of his own choice. It doesn't say to urge the court to retain the counsel of his choice.
I think in that situation, the guardian would again strike. If the guardian believes that it's an inappropriate choice or made at a time that the individual is not exercising rational thought process, the guardian or conservator would move to strike.
Okay, but see, the problem I'm having is this. Let's use this exact case. The conservator says, rightly or wrongly, I'm going to sell your house. And maybe rationally, the guy's like, what do you mean? I get income from that house. It's the stupidest thing I ever heard to sell it. Or maybe it's irrational. The house is a wreck and we need to get the money out and invest it in something useful. Right, I don't know what the answer is. Or maybe they have to live there, right? Whatever. So he comes in. One of two things happens. I thought you said he can't bring in his own counsel and say, I've hired this person. He has to come in and he'll be appointed a counsel by the court under this provision, and either he'll pay for it and the judge will listen. But I like Jane Doe. Okay, great. So I hear what you say. This says, no, they can retain. That's a little different because now they come in with Jane Doe. Now, you say, and then the conservator says they shouldn't have been able to hire that person. They don't know what they're doing. And there's a hearing on that. But they have retained a lawyer in the middle of the guardianship. Can they do that or they can't?
An individual technically could do it as JCS did, and one of the lawyers that JCS hired was a personal injury lawyer to deal with a guardianship and conservatorship set of facts.
Okay, but you're saying they can hire a person. They have a right to hire the lawyer. If they bring in the lawyer, it's not that the court is going to immediately say, no, I'll appoint a lawyer. I hear who you want, but I'm going to do the appointment. There has to be a motion to strike and a hearing on it.
The court can act sua sponte, as Judge Phelan did. Judge Phelan did not let any of the four other lawyers participate in the proceedings.
But didn't the judge hold a hearing and conclude that
Yes, but
JCS lacked the capacity to contract?
Yes, but none of the four lawyers that JCS retained on his own were permitted to present evidence or be heard at the hearing. The only attorneys who could represent, JCS at the time were me as general counsel and Attorney Galloway as Zaltman counsel. So the court made an appointment. The court disregarded JCS's selection, knowing that something wasn't quite right about it.
Okay. It's hard to believe, but these 42 minutes are over. Thank you so much, and thank you. You know, I know the circumstances under which you're doing this, and it's an impossible position, and we really appreciate your help with the case because, as you know, and that's why you're here in part, it's awfully important.
Thank the court for your compassion. It's very
you.
important issues.
We will hear next, I believe, from Attorney Talley, representing at least CPCS, Mental Health Litigation Division, or maybe all of the amici, I don't know.
Yes, good afternoon. I am representing all the amici organizations, which is Center for Public Representation, CPCS, Disability Law Center, and Mental Health Legal Advisors Committee. And thank you for the opportunity.
And we appreciate their participation in the case and your participation in the case and an argument now. So.
Thank you. So I guess I would want to start where Justice D'Angelo started, with the beginning of this case and what happened after the petitions were filed, because I think that will shed some light on some of the questions that we've been asking. Because I think it's important to note from the record that there was no counsel appointed. JCS wanted to appear but never was able to appear. And these decrees, the full plenary guardianship and conservatorship, were entered without any appearance by counsel, any opportunity for JCS himself to appear and contest them, and were entered very, very quickly. So we've talked about, and Attorney Kukia has talked about, the difference between pre-adjudication and post-adjudication. And I would argue that in this case, that adjudication was uncontested, was untested, and so it's important to understand.
What should have happened?
I think what should have happened in this case is that if counsel had been appointed at the outset, either sua sponte by the court, or even if JCS had had the ability to appear, if the judge, which was a separate judge at that time, had just inquired, where is the respondent? Why is he not here?
The respondent wasn't in court even?
No, on I believe it was May 8th. There was testimony, I can't remember if it was in the Zaltman hearing or a deposition or whatever, said that he was living at Transitions at that point in time, and he wanted...
So what was the emergency?
I'm sorry?
Was there an emergency?
There was a motion to have a speedy hearing. I don't
But why
know.
wouldn't the person be present or at least served and then...
Well, I think what happened in this case, from the record that's available to us, is that I think it was on May 8th. He wanted to appear.
How do we know that?
It's in the record. Like I said, I don't know if it was in his testimony at the Zaltman hearing or a deposition or an affidavit of objections that he filed, but that he was living at Transitions. He was dependent on transportation by Transitions, and they didn't come. They were 3 hours late. He couldn't get to the hearing. The same thing on May 23rd.
And what should have happened had he been there? Would he represent himself? Would he have a counsel? Would he have to waive counsel like in a criminal proceeding to represent himself?
Well, I think either of those. If counsel would have been appointed, or even at a minimum, we're talking about the minimum due process of him having the opportunity to appear saying, I want to contest this guardianship, this conservatorship, then at least it would not have proceeded in the fashion that it proceeded.
I want to separate into columns.
Yep.
So we're talking about pre-adjudication.
Yes.
You believe, and I'm going to ask where you believe this from.
Yes.
And I don't necessarily disagree, by the way.
Yep.
At that point, pre-adjudication, all people should have the right to an attorney, whether it be court-appointed or somehow hiring their own lawyer, correct?
I believe so, yes.
Where do you believe that authority comes from?
I think it comes from the MUPC and it comes from constitutional due process. And the arbitrary nature of the MUPC providing that if somebody finds a form, which I know exists and I looked for on the MUP, on the probate court website, it's now filed under miscellaneous. It's an appointment of counsel form. If the person has the wherewithal to somehow find that form.
This is the form that's linked to in your brief?
Appointment of counsel, yes.
Yeah, okay, I've seen that.
It's
form,
301. And so if they have the wherewithal to find that form and submit it, it's mandatory. Court shall appoint counsel.
Okay, now, pre-adjudication, first column, doesn't the judge have the authority, according to what I think Attorney Cougar said, under 190B 5-106, at that point, to appoint?
Yes.
So you think we should expand that somehow and say, shall appoint, or shall have an attorney, whether it be appointment or hire?
Yes. Yes.
Is there any other civil proceeding where someone has to have a lawyer?
In where there's a deprivation of liberty of this significance, and again, to look at...
So criminal matters?
Criminal matters.
What else?
substituted judgment. So in the same type of case.
Is
if
that
this-
Rogers-type hearings?
Section 7, 8, 15, and 35.
But the
Am I missing
equivalent.
one?
Yes, but, right, and the equivalent in the probate setting, when the person's living in the community, is if a guardianship petition is filed at its inception and asks for that additional authority to administer antipsychotic medication, make
No, of
end-of-life
course,
decisions,
okay.
admit to a nursing home, those are situations in a guardianship petition where the appointment of counsel is mandatory.
Can I just want to
Yes,
make sure
no, of
this
course.
is an area I am not
course.
familiar with. Pre-adjudication, a petition's filed by someone, in our example, it was DMH for guardianship, conservatorship. If by some chance, in this case JCS, finds that form somehow and fills it out, you're telling me it's automatic a lawyer gets appointed?
Correct, shall, the statute
So
says shall.
it has to be done by JCS, in this case, finding the form.
Yeah, I mean, that was,
All right.
I think you were asking questions before about how does somebody, go about presenting themselves to the court if they haven't appeared or counsel hasn't been appointed at the outset.
Okay, this is extremely, well, I don't want to interrupt you, actually, it's so helpful, so I'll let you keep
Well,
going.
if you don't mind, if I could just say how to take issue a little bit with the idea that it would be extraordinarily burdensome and expensive to have appointed counsel at the outset in every case. So what might have happened in this case, if counsel had been appointed at the outset, is it is in the record that JCS acknowledged that he needed some help with the properties. He was not opposed to the idea of selling them. He just wanted to know about the proceeds, wanted to consult, wanted further information. That's a perfect case for what we call supported decision-making or some other alternative to guardianship and conservatorship that addresses the specific needs that the person has, but is no more intrusive than what the person needs. Or even in this case, he had nominated his cousin as he was a healthcare proxy. He nominated him in the durable power of attorney for guardian and conservator. Even if it was only that his cousin was given priority.
Who was the petitioner here?
The petitioner was the real estate attorneys, is my.
No, at the very beginning, at the imposition of the guardianship in the first place.
Yes.
Where he didn't get to show up.
Yes.
Who came in and said he needs a guardian?
That was filed by the real estate
A
attorneys.
real estate attorney?
Yes.
Attorney Louisa filed a petition for appointment of JCS, requesting the appointment of.
And who is that person? Like, what is their relationship to
And my understanding is
JCS?
that it's an attorney who he initially consulted because JCS knew there were issues with the property. It was either
So
a
is it someone that
condemnation-
he had hired, or they had no ongoing attorney-client relationship at that time?
I don't know if that's clear in the record, but he initially, I think, went to him seeking help with his real estate issues.
But you don't know that that person was hired. They may have just on their own whim come in and thought, maybe I can sell a house here or whatever.
I believe that there was an attorney-client relationship.
Okay, so now, that actually I think, well, two things. In all the other cases where a lawyer either must be appointed or retained, there's a statute that says it, right? And we don't have that here. So what is the authority? I understand there's this form and it says shall, and I don't know why the form isn't automatic. Under what authority? Is it, do you think it's a constitutional law?
I do, and I think that the MUPC, for all of its benefits to individuals like JCS as a reform statute and trying to narrowly tailor these decrees so that all alternatives are explored before entering such a decree, guardianship or conservatorship, and if it's going to be entered, that it's as narrowly tailored as possible, I think those have constitutional bases. I think the MUPC, in my view, fell a little bit short behind some other states in not appointing counsel in every case or saying there's a right to counsel in every case. Instead, it's if the court.
Well, there is a right to counsel, obviously, under the federal constitution. Every civil case is a right to counsel. But that's not the same as appointing one or being required to hire one. You have a right to do it, right? But all right, so okay, there's no statute, I get that. Now, the person comes in with a hired lawyer. I guess we'll do it, although this isn't about this. Let's start with at the outset.
Pre-adjudication.
Pre-adjudication, the person shows up and here's their lawyer. And just like anyone else, they're like, the lawyer's like, we don't know what this is all about. We don't know who this petitioner is. The person's fine. You know, dismiss the petition or whatever. Is there any mechanism, well, can the guardian and a putative guardian and conservator, the petitioner, can they move to strike that counsel?
Not at that point, because again, there's a presumption that the person
and
has
it's a presumption that can't be rebutted without, okay.
So where pre-adjudication, a petition's been filed, a lawyer is either hired or appointed. Under the UPC, it is the guardian/conservator's burden to show that, in this case, JCS is incompetent.
Well,
Correct?
pre-adjudication, there is no guardian or conservator, right?
Correct.
The punitive, he or she has filed the petition saying, we want a conservator and/or appointed, or conservator and/or guardian for JCS. They filed this petition. That gets the whole thing rolling.
Right.
JCS, under your theory, gets appointed a lawyer automatically. Again, I might agree with you. We then have to have a hearing about whether a guardian or conservator should be appointed. There's a burden there. Under the UPC, the burden is on, and I think
The
even under
petitioner.
common law, under the petition is,
Yes.
they have the burden to show JCS is incompetent, okay? The lawyer that's appointed or hired contests that. So we have adversarial proceedings. We're okay. Everything's good so far.
Yes.
Okay,
And
now, the hearing takes place. The judge says, yes, I agree with the petitioner. He's incompetent. I'm appointing a guardian/conservator, and it should be limited under the UPC, and it's limited to X, Y, and Z. So far, so good?
Yes, and I really appreciate that last piece, because that's what I was going to say. We've been talking about capacity as if it's an all-or-nothing proposition. Either you have capacity or you don't, and we know from the prefatory note to the MUPC that that was what we were trying to get away from.
And does the MUPC require those limitations? That is it under the statute, there are no more plenary appointments? You have to specify, if you're going to appoint a guardian or conservator, exactly what the scope of the incapacity is?
The way the MUPC reads is that when the petitioner is initially filing the petition, they need to specify why a limited guardianship or conservatorship is not appropriate. So yes, there's a presumption.
Okay.
I would view that other less restrictive alternatives, like the person that took the time to execute a healthcare proxy, durable power of attorney, those other types of alternatives that might obviate the need for a guardianship or conservatorship
Okay,
altogether.
so now-
Assuming it's limited.
And we're going to obviously keep going when your time runs out. Now, and I want to do like a decision tree here. A guardian is appointed and a conservator. Let's say the guardian is I want to do limited, and I want to do, the judge finds that limited is no good and it has to be plenary. It's limited, so the guardian is able to make decisions about health care and maybe where they live, I don't know, something, but not everything. And now the person comes in and says, I don't want a guardian. I'd like to remove this guardian.
So now we're into the third column.
Now they have been found incapacitated at least to make these kinds of decisions. What happens now?
So
And let's have it, just to add more branches to this tree, they bring a lawyer in with them. It's Jane Doe. I met her at the nursing home. Or they don't bring a lawyer in.
Judge Rubin's going to hate me. I want to ask a question before
Sure.
we get to
Yeah,
column 3, post-adjudication.
Okay.
During adjudication hearing, you have currently, I guess I should say, under the UPC, there are guidelines as to what the burden is as to, I'll call it competency for guardianship and competency for conservatorship, correct?
Yes.
We have no problem, that's too strong a word. It's clear, correct? The judge has guidelines for that.
Yes,
Okay,
yes,
and you're okay with the guidelines that exist?
yes.
Okay. So now we get to.
Okay,
what
so
I'll
now,
call post-issue.
yes, someone is appointed, actually, let's do it the other way, because it'll be clearer. If the judge finds you need a guardian for everything, and you need a conservator for everything, and that's what I'm appointing with plenary authority, and now the person is sitting around and they're like, I hate this. And they hire a lawyer, and they bring that lawyer in. What is the status of that lawyer? Are they able to hire that person? What happens next?
And what we argue in the amicus brief is that for the purpose of contesting the guardianship and conservatorship, saying it's not necessary, or it can be further limited, that the individual under the
Or
amicus-
for objecting to an action that they're going to take,
An
like
action,
sell real
correct.
estate.
Correct.
All of these ones where they are adverse, or say they are adverse. Is that how they do it? They say they have to be able to verbalize that they're adverse?
I think in your scenario, the person has hired a lawyer, so I
Okay,
am
let's- yes,
assuming
okay,
that
okay,
what
all
they
right,
have
I agree.
hired the lawyer for is for the purpose of challenging the guardianship, and conservatorship, either making it more limited, getting rid of it altogether. They don't like the person, they don't like the decision that they made. That person has the right to have that counsel, whether it's appointed and they argue, or
I'm
under
going
the
to have to
amicus.
separate it because I
Yes.
think there's a big difference. Person chooses his own lawyer.
Yes.
I'm sorry, it's his. The
No, that's
person
fine.
hires his own lawyer.
Their own
Who
lawyer.
pays?
So, and you're presuming that it's a full plenary conservatorship.
Right.
And our position, as we argued in the amicus brief, is that in order to render the rights in the MUPC to have, the most narrow intrusion on the person's liberty, not illusory, that requires counsel, and that requires counsel of the person's choosing, at least for that limited purpose. They're not hiring.
And they pay for it, if they have the resources.
Or they can request that it be appointed, but if
Appointed,
they
but
have
then it wouldn't be-
resources-
I don't want to get too appointed yet.
Okay.
That's different. That's a different chain.
Okay,
We have a conservator. There's money in the pot.
yes.
I'm not even going to tell you how much.
Not
money is-
much anymore because
Well,
of the,
we're going to get there in a second, Judge Rubin. There's money in the pot. He hires a lawyer. You're saying your position has an absolute right to hire his lawyer and has an absolute right to take money from that pot to hire the lawyer to contest it.
For that purpose, the MUPC talks about defending against or prosecuting an action.
Is
And
that right in perpetuity? Because doesn't that defeat the whole purpose of the pot of money? It's going to go away.
could go away.
Right. So again, it's not hiring a lawyer for something that has been reserved to the conservator as their,
Okay,
their
but now-
role.
He made it plenary for
I
everything.
made it plenary for everything. And in particular, although this is I guess it's the same. The conservator has authority over the spending of this person's money. Because if left to their own devices, the judge has found, that money will be gone in an hour. And in fact, it turns out that the lawyer he's hired is from Wilmer Hale. And they think that they need a team of, and I don't mean to single them out, an expensive lawyer who thinks they need a team of 4 associates and 3 partners to really do this right. And everyone's billing rate starts at $1,000 for the first year associate. And that's who he's hired. But he has a conservator who's supposed to not let this profligate spending take place. Still,
Yes, for that purpose. And that doesn't mean that the bills that are submitted by those attorneys are not subject to some kind of.
no, these are
determination
appropriate
about
rates for this.
reasonable
These are
fees.
the going rates for what they do.
Okay.
All right. So now,
Okay?
If it's, yes. if
okay,
it's for this-
immediately the conservator files a motion to strike saying, this person isn't competent to hire a lawyer. First of all, look at how much this lawyer is costing. No one would hire that kind of cost. But even beyond that, the reason I have the conservatorship or the guardianship is they can't make a decision like that. They're incapable of doing it because of their mental illness or their disability or, whatever it is.
Doesn't your theory, and this is in conjunction, under your theory, doesn't that basically moot the whole conservatorship finding? If the respondent can contest everything the conservator does when they've been given plenary authority, they could do it for everything.
Oh, that's true.
Every single thing. That's what the conservator was appointed for. This person can't control their own money. That's the judge's finding. Now, there's been that finding. Day one, that's the finding. On day two, respondent says, I want to buy a house for $500,000. Conservator says, you can't do that. Respondent goes, okay, I want to have this hearing. I'm hiring Hale and Dorn.
Right.
That's okay?
If you're talking about a scenario where it's a decision-making authority that has been specifically reserved to the conservator as opposed to the person seeking to limit the conservatorship or contest the conservatorship, I think that's a closer question as to whether that's an area that
How does it come out?
is reserved to the conservator for the purpose of the
So if the
conservatorship.
conservatorship says all financial expenditures shall be decided upon, then they no longer have that presumptive right to hire a lawyer.
No, I was talking about the scenario where they wanted to contest, the sale of the house or a specific decision made by the conservator with respect.
Okay, but that's what this case is.
Aren't I correct in saying that there are some conservatorships that the conservator controls every financial aspect of the person's life? And in order to get money, they go to the conservator and say, I need this for this. So under our scenario that Justice Rubin posed, it's everything. So they're questioning the authority of the conservator to do anything. And that just, to me, that ignores the finding the judge has formally made if they have a right to contest everything.
But again, I think the position that we took in the amicus brief is that hiring or having a lawyer appointed for the purpose of the due process purpose of making sure that the decrees.
All right, so you say they have to have this right.
Conservatorship, yes.
And on day one, to take Judge D'Angelo's example, they find out that the conservator has paid the electric bill. They are outraged for no particular reason. They hire a lawyer and they come in and say, this expenditure is no good. And they've hired the lawyer and there's a presumption and they go in. And if it is ultimately held, no, they can't do that, can they still come in on Thursday now and say, and now he's paid the gas bill, and that's an outrage. And now he's paid the cleaning person, and that's an outrage, or the septic, you know what I mean?
Yeah.
Do they get to have a lawyer, or is it res judicata or something at some point? I mean, I understand people's circumstances change, right? But still.
Well, I think, again, arguably, those types of decisions where it's for the benefit of the individual, it's paying the electric bill, it's paying the gas bill, those are things that are reserved to the conservator under the conservatorship.
But as a matter of due process, can't he contest, like the sale of the real estate? That's what this is. Someone decided, we're going to sell your house. And he's like, what? No. I've hired this lawyer to contest that.
Right. And again, going back to what I think is the original problem with this case is that the lack of due process at the very beginning, where JCS was willing.
I think
Okay.
the three of us are with you.
Okay.
That maybe at some
Okay.
point
Yes.
in the three columns, I'm
Yes.
a very simple person, three
Yes.
columns, somewhere in those columns should have a right to a lawyer. But at some point, you can't just keep coming into court because you're
Correct.
diminishing what the whole conservatorship was established for in the first place.
Correct.
And we're trying to figure out where's the line and how do we do that?
And so one of the articles that we cited in the amicus brief that I found very helpful, and hopefully you may find it helpful on this issue as well, is the Cohn and Koss article. And it talks about the doctrine of necessities, looking at why contract law or applying contract law to this situation, and viewing the retention of counsel for the purpose of challenging a guardianship, a conservatorship on due process grounds as something that could fall under the doctrine of necessities. As
All
an
right,
exception
so
to
let's
contract
go
law.
down. Let's leave to one side challenging the electric bill. Let's even leave to one side challenging the sale of the real estate, although we ultimately can't leave that to one side because that's the case. So someone comes in and they say, I hate this guardian, I hate this conservator, I want them gone. I have hired Jane Doe. And the judge says, well, of course, that's fine. You have a presumptive right to hire counsel, even though you're under a completely broad conservatorship and guardianship. And 4 minutes later, the conservator brings a motion to strike. Does the judge have authority, if he makes certain findings, to strike that hiring?
Again, I think that the conservator has potentially a conflict, but I also think that the court has a role in making sure that
Okay,
the
but
person
if it's not an adversary
protected.
proceeding, or you're saying it's not an adversary proceeding, the court must sua sponte determine if this person was, I'm going to use the word competent, although I want to steer clear of that for a bunch of reasons, right? But competent to hire a lawyer. Oh, you've brought Jane Doe in, terrific. Does the judge do this sua sponte, or the other party can move to strike, or they can't because it's the lawyer who's against them?
And I'm sorry, I think I've gotten a little bit lost. Can you remind me in this particular scenario,
Okay.
what is the purpose that he's hired
It's
Jane Doe for? 'Cause
plenary,
I've got
it's a
little-
plenary conservatorship and
Yes.
plenary guardianship
Yes.
due to an intellectual disability. Nonetheless, the person can speak and can, to some extent, sort of reason within a tiny parameter, and they say, oh, I hate the guardian, and this person says, well, I'm a lawyer, I can help you. And they're like, I would love that. And they hire them. Okay. And now they come to court with the lawyer they've hired, and the conservator thinks, they can't decide to buy a sandwich. How can they hire a lawyer? Or the guardian does, and they bring a motion to strike the hiring. Can they do that?
I think in this situation where the person is seeking to remove the guardian, that is much closer to a situation where they're contesting the existence of the guardianship.
Yes, they
Because
are contesting that.
Because that guardian, the person of that guardian, is also critical to the individual's
Okay, so you're saying they
exercise of their due
cannot
process.
bring that motion?
That the
Guardian and
to strike.
conservator, who are the only other parties to the case at this point, they can't bring a motion.
I mean, anyone could file a motion for anything, but I'm
But you're saying
that
it
I
should
think
be,
that
they
is-
should be ruled not to have standing to bring that, or not to have authority to seek that, because this seeks their own removal and they're self-interested.
They're self-interested, and also as the individual in this situation, if they are a person with an intellectual disability who has the ability to express, I don't want this guardian, and presumably they found the lawyer, they expressed to the lawyer the reason why they don't want this particular guardian. The lawyer determined that they had some limited ability to say, I want to hire you for this purpose. This is the reason why I don't like this
Okay.
guardian. It's a non-frivolous reason.
Where do we get that from? Because that was my next
And who's
On
here,
day
who's
two-
hearing?
on
Let's say
day-
the reason
again,
they.
simple minds
Yeah.
do simple things. On day two, they say, I don't like the conservator, I want to fire. There's some type of hearing where on day two, the judge says, yeah, I'm going to let that lawyer go forward. The judge goes forward and says, nope, still keeping the conservator. Okay, now day three comes and he does it all over again. At what point does it become frivolous, and who determines and how does it become frivolous?
Right. And I think there were cases that are cited again in that same article from other states that, impose some limited conditions on this.
Under the
What
MU,
you think
under the
it should be.
UPC, under parallel statutes.
Similar.
So, again, I think if it's central to, the exercise of the person's rights and who the.
Counsel, I'm trying to
Okay.
simplify.
You're saying if
Who
they do it over and over
They
again?
keep doing it. They do it on date three.
Right.
Who makes the decision? Does the I guess it would be a petition to remove conservator, if I have my memory is right. And that, does it automatically get brought to the judge magically, and the judge looks at it and goes, this is frivolous, denied? Or does there have to be some type of hearing?
No, I think there has to be some kind of hearing.
Who has to prove what at the hearing in order for that lawyer to be removed?
In order to strike the appearance of that
Yes.
lawyer, if it's the third time
No,
and they've
the
done
first
something.
time.
Time after the post-adjudication.
Yes, it's the first time under a guardianship this person has appeared in court, and it's to remove the guardian. And they've hired Jane Doe. Who can strike the appearance, under what circumstances, with what, proven by whom, can the judge strike the appearance of the lawyer?
I don't think the judge can strike the appearance of the lawyer without some finding that the lawyer has acted inappropriately or is
No.
billing unreasonably
Do you
or-
think that, because you don't, do you think that if we ask a child, children can speak and reason, within frameworks and so on, and we say to the child, blah, 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 and the child says, yeah, I would like my own lawyer. And so here comes 7-year-old whomever with their lawyer, Jane Doe. Surely you wouldn't say that they have the right to hire a lawyer. There's a presumption, and it can't be removed unless the lawyer did something wrong. And the lawyer did nothing wrong. It's a smart kid. They found a lawyer.
So I think that brings us, the scenario you're positing brings us back to the issue of capacity, that you hold
Okay,
something
but
like
you
a
said
Zaltman
their
hearing
capacity
that-
has nothing to do with it.
Correct, and I'm saying there's.
So a
there should
7-year-old,
be
a 7-year-old can hire a lawyer.
Somebody with a disability that, assuming somebody thinks that.
No,
they
I'm
have
asking about an actual 7-year-old. I'm not asking about some.
Actual 7-year-old?
Yes.
Oh, when, I thought we were
And
talking
they or
about
they
an
can't.
adult. 7-year-olds in
Lack
guardianship.
capacity under the law to form a contract. We're asking, is this the same?
No, not if you're talking about.
Why
it's an adult.
not?
Why is it?
It's because you have an adult person who may or may not have.
No,
what you're saying.
May, because the judge has already made a finding. We're talking about post-adjudication. The
Right.
judge has already made a finding, he or she is
And
incompetent.
if that person has the ability to say, I want to hire a lawyer to contest this guardianship or conservatorship, or the person, remove the guardian or remove the conservator, yes, the expression of that legal desire, and they need a lawyer to effectuate
The guardian
purposes
is
of
the
MUPC.
guardian has that person as their ward, right? That's the word that's used.
No, it's not.
They're not a ward anymore?
Not for an adult. It's only used for a minor. That was one of the things that the MUPC got rid of.
Okay,
because it was
so what's it
viewed
called
as
now?
a protected person or incapacitated
And the
person.
protected or incapacitated person does the role of the guard, I mean, in many of these cases, the guardian is going to be the parent. The child has turned 18, they're severely disabled, and they need a guardian, okay? But they're able to say, I don't like it, just like they were when they were 10, but now they're 19. When they're 10, we say, we know you don't like it, right? We get that, and we're not denying it. But you can't hire a lawyer because why? Why can't the 10-year-old hire a lawyer?
Again, the law treats.
I'm not
them
asking,
differently.
yeah, well, we're trying to figure out what the law is. Why is the law allowed to treat a 10-year-old differently than an 18-year-old?
Who's incapacitated?
Because the 18-year-old who's incapacitated is entitled under the MUPC, and it's not just their responsibility to ensure that the guardianship and conservatorship are only as, intrusive as necessary. And that's an ongoing and changing and fluid ability. So even in your scenario where it's an adult with a developmental disability, if that guardianship was imposed when that person turned 18,
Sure.
then there seems to be an assumption that that person is never going to develop.
Not an assumption.
It's
Not an assumption. I'm willing to say the presumption is they can hire a lawyer. They're an adult. I'm willing to go with you all the way to they have a guardian, but they can still be presumed but it's a presumption. It must be possible to overcome it and say, I'm sorry, the judge has to appoint your lawyer. You don't get to pick any lawyer you want, and you don't get to pick this person who knows a great deal about real estate, but nothing about guardianships. And that was a choice, and the reason you made that choice is you didn't even know to ask because of your disability. So the judge will appoint an appropriate lawyer, and you will be represented, but not by this person you chose because your disability has rendered you unable to make a rational decision about who your lawyer should be.
No, again, what I was
No,
starting.
you think that regardless of the level of disability,
Yes, if the person is.
if they
able to
hire
exercise-
the wrong lawyer, a lawyer with a specialty that is not guardianships, a real estate lawyer, we go. That's not going to be a very good hearing for the incapacitated person, is it?
No, but I think what we're left with is the MUPC saying that the appointment of counsel shall not be construed to abridge the right of the person to retain their own counsel.
So-
And I
At any
think-
time.
I'm
I
sorry.
want to make sure your position is at any time, even post-adjudication.
Yes.
That's
and-
that's
and-
where
and
that's where the rubber meets the road for me, is we've had a finding, and I'm not saying it's permanent. And I might ask a question about that.
Right.
But your position is, at any time, incapacitated person has the right to contest the guardianship/conservatorship with an attorney that he or she either hires or is appointed, any time.
Yes, but I think,
Let me stop you there. Again, because I'm trying to find where the goal line is and where the parameters are here. Court appointed is a very different situation. They're not indigent. Under CPCS, you're only supposed to be appointed an attorney if indigency takes place, right?
but there are provisions in probate court where the court can appoint, even if the person has some funds, can still check the box. I think Attorney Cukier referred to this, that says the funds are to be paid by the Commonwealth.
And
But
that's
Amy-
under your, again, now I'm going back 2 seconds ago.
Yes.
Under your theory, that's any time. That's any time. Do you really think that's good for CPCS? Because any time after that post-adjudication, you just told me that person has the right to contest guardianship/conservatorship and has the right now to appointed counsel. So they check the box in every case.
If the purpose, again, is for contesting it and saying it's not necessary, because otherwise, if there is no substituted judgment proceeding involved, and the person is appointed a guardian with say it's an adult with a developmental disability, when they turn 18, and they have no ability to hire or have appointed counsel or get back into court, then the risk under the MUP is that you return to what the MUPC was trying to get rid of,
The
which is that plenary
MUPC, the
guardianship
MUPC
continues.
says that the funds can come from the estate of the incapacitated person. It does
Yes.
not say CPCS. It says if they're not indigent, they can come from the estate. So the judge, thinking, well, CPCS needs its resources to do all the other stuff it does. This person has hundreds of thousands of dollars in the bank. I'm not going to have CPCS pay for that, but I am going to appoint a lawyer, and the funds will come from that person. They can do that, right?
Yes, I think, again.
Okay,
for the-
but you're
for the
saying if the
purpose.
person walks in with someone, totally inappropriate, can the judge sua sponte, never mind a motion by the guardian? The judge sees the lawyer and is like, Ms. Johnson? And she's like, oh, hello, Judge. And the judge says, I haven't seen you since that big real estate case. Oh, no, Judge, that was a great time, but now I'm doing this. Oh, do you do a lot of these? This'll be my first.
And so
The
that-
judge can't say, well, sua sponte, well, this is a very disabled person you're representing, and I understand they hired you, but I think that the very act of hiring you demonstrates an incapacity to make a good judgment about this. I'm not going to leave it to the guardian or the conservator to decide who the lawyer will be, because they're conflicted. But I'm going to appoint Ms. Jones because she does these all the time. She's the best getting rid of a guardianship lawyer I know.
But wouldn't that raise a problem under the ethical rules so that the judge is looking at the person as somebody who has taken on representation that they're not competent to provide? If they're a real estate attorney and they don't have any experience?
Real estate attorneys can. It's going to be pretty expensive because they're going to have to spend months reading books about how guardianship proceedings work, but they're allowed. They have a license.
Well, again, I think that goes back to the rules of professional conduct, that that's one means of ensuring that
So
somebody...
the judge can only find, oh, I'm sorry, I know you're a terrific lawyer and everything, but you violated the rules of professional conduct, so you can't represent the person. In fact, I think I have to report you now to the BBO.
I thought that that was what your hypothetical was getting at, is that somebody is clearly not qualified
No,
to
but
do that kind of proceeding is higher.
but the decision is very, very poor. And it turns out when you say to the person, you know they practice real estate law, not guardianship, the person says, what are those? Because of their intellectual disability. And so real estate, I don't know what that is. That's property law. Oh, okay, I have some property. Well, but this is a guardianship. What is that? Right, I mean, I just don't know.
If the person doesn't have the ability to know what a guardianship is and that that's what they are seeking, I think that's consistent with the position that we take in the amicus brief.
Okay, they don't know what a guardianship is. They know they don't like this person telling them where they can live. They don't know what a guardianship is, though. They can't, the court can somehow not allow them to hire counsel.
No, I think you changed the hypothetical by saying, you know, they don't know what guardianship is. If you were thinking about it in legal terms and the person knows from their personal day-to-day life, I have somebody else who is controlling where I live, how much money I can have, what decisions I can make. To me, that's an understand, and I want to change that.
They've expressed that.
And they've expressed that. To me, they understand what guardianship means for them. And in terms of the choice of counsel, that's something else that we discuss in the amicus brief, is why somebody on the surface who may appear to have more expertise in guardianship proceedings may not be the person that the individual is choosing. And I think some of the examples that we gave are, it could be that there is a personal rapport, that the individual who they're selecting has a better way of communicating or accommodating the person's disability. So it is true.
Do they
that
have a
choice is
constitutional right to spend their own money? Do you or I have a constitutional right to spend our own money? I'm going to go yes. Right, because our life, liberty, or property can't be taken without due process of law, and our money is our property.
Yes.
There's been a hearing, and this person's, that right of theirs has been extinguished. There's now a conservator in place. They can't spend their own money. Why can't their right to counsel similarly in this extreme right? I mean, it's got to be narrowly tailored to a compelling interest, right? But there's a compelling interest in not dissipating their estate.
Right now, it's the best mechanism that we have for ensuring that the MUPC is...
Can I maybe give a middle ground?
Okay,
Maybe, instead of this forever and for always? I think, under the statute, these are supposed to be reviewed at a minimum, I think, annually, correct?
No, that's the problem, and that was what the scenario that I was getting at with the 18-year-old, where there is no substituted judgment. A person can be told, the parents can be told by the school, by the doctor, whoever, your son or daughter with a developmental disability is about to turn 18, you need to go and get guardianship. And they may never have a right to counsel, they may never have a hearing, and that is never revisited ever again.
Wait, I want to stop.
I thought the guardianship statute and the conservatorship statute says the judge builds in, like under a 35 and a 7, 8, and I think 9, there's a line where the judge has to put a minimum of 1 year. Can be sooner. That's not
It
your...
is only for substituted judgment determinations for...
I have a question about
antipsychotic medication.
substituted judgment, because you've raised that twice as an exception. What are you talking about?
Oh, I'm sorry.
Like, when is it a substituted judgment case?
So again, if the petitioner is seeking what's called extraordinary authority, so there are certain decisions, I'm going to take guardianship, that a guardian can make involving medical care, ordinary and customary decisions. Give my person antibiotics, have them have an MRI, whatever, things like that. But the law, and Attorney Cukier referenced Sakowitz, I believe, since 1977, we've carved out certain types of medical decisions that are considered too intrusive and for the guardian for that authority to be delegated to the guardian.
That's under Chapter 123, isn't it?
It's also under the MUPC 5-306A. Codifies Rogers and Roe and all of those.
So now, what about?
But wait. I want to stick on substitute judgment for a second. So that's the only kind of proceeding you're talking about?
No. That was in response to Justice D'Angelo asking, don't these have to be reviewed every year?
Okay, but I want to understand when you say substituted judgment is different. Can a guardian be charged with exercising substituted judgment?
No.
Why not?
Because the court, and again, it goes back to the Sakowitz case in 1977.
Okay.
The SJC has said there are certain types of decisions that are for the court, and when they involve these types of extraordinarily intrusive interventions.
Now, CPCS has guidelines, I don't know if you're familiar with them, for their DCF cases, maybe all cases, where children are represented. And when children are under a certain age, the standard is the lawyer is to act in the best interests of the child. At a certain point, I don't know if it's age-based or how it works exactly, the lawyer is required, and these are ethical obligations, are required to exercise substituted judgment. Maybe it's the other way around about age, I have no idea. That is to try to figure out, in light of the child's values or the family's values or something, what would this child choose if only they had the capacity? Why shouldn't we be doing something like that with respect to the appointment of or hiring of a lawyer? Have the judge determine, this person lacks capacity, but if they had capacity, they would want a lawyer. You know what I mean? Rather than just saying you go hire, in every case, you go hire someone. I mean, I find it hard to imagine that just whoever you randomly hire, and I've seen some random lawyers, that's who's going to represent you in this incredibly important determination hearing.
I don't think we have a provision for the judge to engage in substituted judgment.
Well, we strike appearances all the time, right? But you think the only ground for striking is unethical conduct by the lawyer?
Again, we're at somewhat of a disadvantage because at CPCS we deal with appointed, counsel. So I have to say, in terms of all the scenarios where a probate court judge might strike the appearance of, a hired lawyer, but
what if we somehow, and I don't know what authority we'd have, but maybe we could find one somewhere, to mandate that guardianship / conservatorships have to be reviewed 1 year. And if there is any objection, a lawyer could be appointed for that. Is that a middle ground? That seems like, because that's what we do in Chapter 123 cases.
yes.
Although our actual question is, what if they show up with a lawyer they say they've hired? That's what we're really dealing with, is we're not saying, and the statute says, you don't have to appoint, these people can retain.
Right.
And now maybe it just means what it says, and the legislature can fix it if they didn't really mean that. I think there's going to be dangerous and bad outcomes for these incapacitated people if we have to accept a profoundly disabled person's hiring decision. Don't you? Aren't you concerned about that? Isn't that more important than this procedural step of, well, we respected their wishes. They hired someone largely inappropriate, but a licensed attorney.
Well, again,
What if they're subject to undue influence? What if, not that it's been exercised yet, but it could be. So the lawyer could have a kind of control over them that we wouldn't want.
Right. And I think in this case, that's obviously what happened. You had a very unusual scenario where somebody was exploiting his desire.
So what should have happened?
In this case, he actually fired that attorney. He himself, and I guess that's the issue that I have with painting a picture of somebody as so completely disabled that they...
I have to, I'm not painting any pictures.
I'm sorry.
We're trying
I
to
didn't mean
figure
that
out.
in a negative way.
We're trying to figure out, or at least I know we are.
Yes.
Where the goalposts are, where the lines are, where the columns are.
Because these are reported questions, right? And the reported questions are broader than, and I don't know what the rules are about having to answer them the way they're framed, or you know what I mean? But they are far broader than this particular case. And maybe, I don't know if anyone was found to have done something literally unethical here, but there were motions to strike all of these lawyers, right? And in fact, in the end, the person was represented by appointed counsel. Is that objectionable? You think they should have been able to have the second person they hired?
I'm sorry, the second person that they hired?
There's four.
The lawyer they hired versus the court-appointed lawyer. Should the incapacitated person have that right to say, I don't want the court-appointed
Yes.
lawyer, I want the person who I'm spending money on?
Yes, I think under the MUPC, it gives the person the ability to choose a different lawyer.
That's what I
than the
thought
one
your
who's
position
been
was in your
appointed.
brief.
Yes.
But you've said if they don't understand what a guardianship is, not in my sense of they don't know what the word means, but they don't understand it at all. And they may not, right? They may not understand it's because of their disability. They may just not like that someone is spending their money and telling them where to live without understanding, well, it's been appointed by a court. They might not understand that. How does the court inquire into that? Sua sponte, motion to strike?
And I agree that it's an imperfect system because we don't have any other mechanism for review. The burden, yet, what we have here is an imperfect system where you could have a plenary guardianship and conservatorship that is never reviewed unless the individual themselves somehow has the wherewithal to get themselves into court and say this should be limited or this guardian should be removed. So I agree with you that it's an imperfect system, but I think the thrust of the MUPC and the constitutional rights have to give that person the ability to have counsel to get back into court to revisit those plenary guardianships and conservatorships.
I feel Judge Smyth has a question.
Well, it's related to Justice D'Angelo's. What are the safeguard would you see for the person, again, who doesn't have the capacity to bring a challenge or a complaint, who may have, for lack of a better term, fallen through the system?
I mean, the statute does provide for other people to, request counsel on the person's behalf. I honestly don't know how often that is invoked. We do have the case of guardianship of BVG, where that was an adult person with a developmental disability who's, I think, maternal grandfather. The father was the guardian. The maternal grandfather wanted to have visitation, and he was determined to be an interested party under the statute, but it was for the purpose of narrowly tailoring the guardianship, that the guardianship had not been limited enough. There was not, and the court ruled in that case, there was nothing wrong with visitation by the grandfather. The adult daughter wanted it, and so because they deemed that person to be an interested person under the statute, they could help facilitate the adult daughter's right to have a more narrowly tailored guardianship decree. So,
Not every incapacitated or protected person has an interested party.
yes, correct.
Initially, when I asked your sister, at the end of your brief, you cite to, again, this group that met at Syracuse. And one of the recommendations they make is, I think at 3.1 or 3.6, is to appoint counsel for every hearing. And again, would that be a mechanism, a prophylactic, mechanism that ensures the rights of every protected or incapacitated person? Is that what you're advocating for, or do you think that's a step that's not necessary?
I think appointment of counsel for, are you talking about the post-adjudication as well, or at what point? So Well, but how did the hearing come about in the first place? I understood your question to be if we appoint counsel for every hearing, but I think the issue is how do they get back to court in the first place? So that gets back to Justice D'Angelo's question about do we have some type of review? Guardians and conservators are required to file care plans, and in those plans and accountings, and in those, plans that are supposed to be reviewed, they are supposed to say whether or not the person continues to need the guardianship or conservatorship, or whether it can be more limited. So in theory,
Guardians themselves?
yes, that's what the MUPC provides.
That seems like bad business, doesn't it?
And that's
But
that's supposed to be, and I can't speak to whether it is, that's supposed to be reviewed by the court, correct?
Yes.
I think
Yes.
that's what I meant by the review. I
Oh,
didn't
okay.
mean a court hearing. But there
Okay.
is a review process that's supposed to take place.
And I think that's the issue here, is that all of these things look very good on paper, and Justice Rubin, to your question about does the guardian and conservator have that obligation, the court, the conservators, the guardianships, everybody involved is supposed to have the same goal and the same aim under the MUPC, which is to make sure that
Yeah,
it's
but they
narrowly tailored.
frequently don't. When there's money involved, I don't know if you've seen the newspaper.
Frequently, I think Councilor,
Okay.
the low percentage of cases, there's a problem and come back, but we can agree to disagree.
Well, we don't have,
And again,
we don't have good data.
in this case,
on
I
this.
think if counsel was appointed at the outset, some of this would have been avoided.
More questions? No? Thank you so much. All of you who've been involved in this have been incredibly helpful to us. We really appreciate Miki's participation and your willingness to do this and take our questions. It's obviously a very complex area of law that is under litigated and under resolved. So we really appreciate your assistance. With that, I'd like to thank the court officer and the court staff for their assistance, and we stand in recess.